conditions on your green card when you're going through a divorce can be a complex process, but with careful preparation and understanding of the requirements, it can be navigated successfully. Here are some tips to help you through the situation. First, know the timing for filing your Form I-751, which is the petition to remove the conditions on your residency. This must be filed within the 90-day period before your conditional green card expires. So even if you're divorced or separated, you must still file this form to avoid losing your permanent residency status. Second, file for a waiver. This is done on the same I-751. But if you are divorced or your marriage has been annulled, you cannot file a joint petition with your spouse anymore. Instead, you will need to request a waiver of the joint filing requirement. You can file for a waiver based on one of the following grounds: good faith marriage, proof that your marriage was entered into in good faith, even though it ended in divorce or annulment, just that it was, at its inception, a good faith marriage. You can also prove extreme hardship or battery or extreme cruelty, but most people can file their waiver based on good faith marriage. While this is happening, third, gather strong evidence. Supporting evidence is crucial to proving your case. This may include proof of cohabitation, so documents showing you live together, such as lease agreements or a mortgage statement, utility bills, joint bank account statements. USCIS will also want to see some financial interdependence, so evidence of your joint finances like a jointly filed tax return, joint credit card statements, and joint insurance policies. Sometimes you can also include affidavits. These are statements from friends or family, and maybe others, perhaps even your ex-spouse, who can attest to the veracity of the marriage at its inception. You also will need your divorce decree. The final divorce decree and the related documents to the divorce will be necessary for USCIS to adjudicate your petition. Finally, any additional supporting documents that you might have, which could include photos, correspondence, emails, texts, and other items that show the relationship was genuine. This is very much like what you used when you filed your I-130 to prove the marriage at its inception. Finally, prepare for an interview. USCIS may require an interview in these waiver cases. Be prepared to answer questions about your marriage and some of the reasons for your divorce as well. Answer honestly with clear and direct, short answers. By following these tips and seeking professional guidance when needed, you can increase your chances of successfully removing the conditions on your green card, even in the midst of a divorce. Palo Alto Immigration is here to support you.